Welcome back, or should I say welcome back? I have to say, oh my, oh my. During my last episode, I discussed Article 2 of the Constitution, dealing with the presidency, You heard me recite Alexander Hamilton's words over and over again, that the president was not a king. At least 10 times, Hamilton in the Federalist 69 stated that our president was not a king. Most specifically, he said the president, would be amenable to impeachment for high crimes and misdemeanors, suffer personal punishment and disgrace, and would, now get this, would afterwards be liable to prosecution and punishment in the ordinary course of law. The person of the other, and he meant the king, is sacred and inviolable. This principle has remained alive in our laws, in our lives, and in our hearts until July 1, 2024. On this black day, the Supreme Court of the United States, a body without ethical standards, an organization riddled with corruption, and an organization so lazy that it only hears 70 cases out of the 7,000 appealed to them annually, handed down a decision which virtually makes the President of the United States a king. The court members receive hundreds of thousands of dollars in pay and still take a 3-month vacation, setting aside the cases they haven't heard. During their time off, many of them earn more money on the side by teaching at overseas universities, giving paid speeches at right-wing and left-wing think tanks, and living high on the hog, taking vacations paid for by billionaires. Bathing in their greed, corruption, and sloth, they've placed our democracy on the precipice of devolution into a dictatorial abyss. The Supreme Court case number 23-939 stated the following: held, under our constitutional structure of separated powers, the nature of the presidential authority entitles a former president to absolute immunity from criminal prosecution for actions within his conclusive and preclusive constitutional authority. And he's entitled to at least presumptive immunity from prosecution for all of his official acts. There is no immunity for unofficial acts. In Federalist 69, Hamilton specifically wrote about the powers of the president and said the king is sacred and inviolable. However, that's exactly what the court made the president in carrying out his official duties. The president is now also inviolable. The decision has a number of mentally deficient gyrations in it. First, it never discusses Federalist 69 in depth, but does throw in Federalist 70, which is totally non-ad rem or not to the point. The Federalist 70 primarily discusses the difference between having executive power vested in one person or more than one person. It even discusses the assumption of power by dictators, Caesars, in the Roman Empire. Second, another very disturbing element in the decision, the court didn't define official acts. This lack of definition creates an absolute chaos in a number of directions. It gives any future president the ability to claim that any of his or her acts are official acts. On the other hand, it gives every presidential antagonist the chance to file a legal action against the president claiming that what was done was not an official act. There are 96 federal district courts and 13 federal courts of appeals in the United States. Anyone wanting to tie up the implementation of an executive action can and will file a suit in those courts claiming that the executive or presidential action was not an official act. On the other hand, if you knew that you were injured or damaged as a result of an alleged official act of the president or executive, can you imagine how long it would take you to go through all of the court process and then to the Supreme Court of the United States to determine if an action was a legal or illegal official act. In the past, hundreds or thousands of people impacted by the Tuskegee experiments, the secret Hanford radiation tests, or the Tonkin Bay resolution were denied justice as a result of a terrible justice system in the U.S. and illegal and superficial protections of our government and executive. Now we have an additional thumb on the scales of justice, pushing justice against the federal executive, placing it without the reach or outside the reach of the average citizen. The latter should cause grave concerns for all of us as individuals and citizens who must now live under the threat of potentially despotic and dictatorial conditions. And this is not only because the case just decided is entitled Trump versus the United States. While many people feel that threatened by the possibility that Trump will be re-elected and wildly use this new freedom to seek revenge on all of his opponents, including judges, attorneys general, state election officials, and others who have opposed him, which is possibly truth. However, the crass reality is that this decision will spread a plague on our country for at least 100 years and at least 20 presidents' terms of office. It will now be possible for the President of the United States to undertake an official act of declaring a national emergency based upon massive illegal immigration, order the mass incarcerations of political opponents in sanctuary cities, including those making jokes about him or her. It would expose you and every opponent, every blogger, Facebook poster, reporter, local election official, and state election officer to rendition. We could all be taken to a black cell in a foreign country under CIA cover where there is torture allowed. Your family wouldn't even know where you were because habeas corpus wouldn't even be enforceable. And who is to say that all of this is not an official act? The Supreme Court doesn't define it. Can you? Can you define what's an official act? The next time there is a mass shooting in a school and 20 children and 4 teachers and 2 policemen are killed, the president can declare a national emergency, stating that we have too many mass shootings, all made possible by assault-style guns. He can order the Alcohol, Firearms, and Tobacco Administration to seize the sales records of all the gun stores to identify anyone who's purchased an AR-15 or similar weapon. Then the president can mobilize the National Guard to assist the AFT in confiscating all the AR-15s and similar guns in the U.S. Wouldn't this be an official act of the president? The Supreme Court didn't define it. If you think you can, try. Now, if you think these official actions are not possible, remember history. On February the 28th, 1933, the German Chancellor announced what's now known as the Enabling Acts. They were issued to protect the state against the violent act of the communists. The following personal liberties were set aside, including freedom of expression, freedom of the press, freedom of association, the right to hold meetings, giving the right to take letters out of the mail. Other mail and telegrams and long-distance calling privacy was removed. Arrangements for searching of homes and seizures of property were done away with. 1 month later, special courts like military tribunals created under President Bush were set up. If some of you don't think it can happen here, you haven't read my book. It has happened here. But the courts, if you could afford them, stood behind our freedoms and the limitations of the presidency to correct most of the wrongs. Now we have neither, thanks to the opinion of the Supreme Court. I'm Donald Cleveland. I'm the author of Revitalizing America, A Declaration Against Our Government. And if you're interested in buying the book, be sure that you buy the new second edition. It has many updates in it. It was published a couple of months ago, and I think you'll find it very interesting.